The Secretary of Homeland Security now finds herself at the center of what can only be described as one of the most extraordinary accountability crises in modern American governance. Multiple branches of government are simultaneously scrutinizing her conduct, each raising independent but converging concerns about legality, truthfulness, and respect for institutional authority. At the judicial level, the Chief Judge of the D.C. Circuit Court is seriously considering whether to hold her in criminal contempt and to refer the matter not to the Department of Justice, but to an independently appointed special prosecutor. At the legislative level, members of Congress have openly warned that her testimony may constitute perjury due to deliberate evasiveness. The convergence of these threats is unprecedented in its scope and severity, particularly for a sitting cabinet-level official. At the heart of the judicial controversy lies a stark allegation that the Secretary authorized the deportation of approximately 200 individuals to El Salvador in direct violation of a federal court order. These individuals were allegedly sent to detention facilities widely characterized by human rights organizations as environments tantamount to torture. The judge had issued a clear and binding order halting deportation flights and requiring that the individuals be returned to federal jurisdiction so proper hearings could be conducted. A federal court order is not advisory. It is not optional. It is a legally enforceable command backed by the full authority of the judiciary. Yet despite this order, flights reportedly continued, planes departed, and people were removed from the country. This raises one of the most fundamental questions in constitutional governance. What happens when the executive branch ignores the judiciary? The administration's defense has been that it relied on advice of counsel, but the law is clear that reliance on legal advice does not automatically shield officials from contempt, particularly if that advice was flawed, selectively sought, or used as a post hoc justification for actions already decided upon. Recognizing the gravity of the situation, the judge has scheduled evidentiary hearings and has taken the unusual step of personally examining witnesses. This includes testimony from attorneys within the Department of Justice and whistleblowers who believe the court's order was knowingly defied. The judge's objective is not merely to establish what happened, but to determine the state of mind of those involved, whether they genuinely believe they were acting lawfully or whether they knowingly violated a judicial command and hope to avoid consequences. What elevates the seriousness of this matter further is that the administration itself identified the Secretary of Homeland Security as the official who authorized proceeding despite the court's order. This is not a case of a mid-level bureaucrat misunderstanding instructions. It is an allegation that the highest-ranking official in the department personally approved defiance of the judiciary. Should the judge determine that criminal contempt is warranted and appoint a special prosecutor, it would mark a historic moment. A cabinet secretary facing criminal prosecution for actions taken while in office. Such events are rare precisely because they strike at the core of the rule of law and the principle that no individual, regardless of rank, is above it. Simultaneously, the Secretary's appearance before Congress has generated its own legal peril. During a contentious hearing, lawmakers pressed her on a deceptively simple factual question: who approved asylum for the individual responsible for shooting members of the National Guard in Washington, D.C.? The factual record indicates that this individual, an Afghan national, was granted asylum during the current administration. Observers familiar with asylum processes quickly noted that such rapid approval typically reflects prior cooperation with U.S. military or intelligence agencies. Indeed, the individual had worked directly with U.S. forces and was relocated and protected on that basis. This decision was made under the present administration, not the previous one. An inconvenient truth given the administration's public narrative attempting to assign blame elsewhere. Rather than provide a direct answer, the Secretary repeatedly deflected, reframed, and avoided the question. Congressional leadership explicitly warned her that such evasiveness could form the basis for perjury charges. Under U.S. law, perjury is not limited to outright lies. It also encompasses deliberately misleading testimony designed to obstruct congressional oversight. Matters deteriorated further when the secretary abruptly attempted to leave the hearing, citing a supposedly urgent meeting. It later emerged that this meeting had been canceled and that she was aware of its cancellation. Using a false pretext to escape congressional questioning is not merely disrespectful, it may itself constitute obstruction or contempt of Congress. When summoned before Congress, witnesses do not control the proceedings. Congress does. Attempting to flee a hearing raises obvious questions about what a witness is trying to avoid answering. If testimony is truthful and complete, there is no need for evasion. The Department of Homeland Security wields enormous power over immigration, border enforcement, national security, and emergency management. When the person leading that department refuses to answer basic factual questions about decisions made under their authority, it represents a five-alarm fire for democratic accountability. This is not about classified intelligence or sensitive national security secrets. It is about timelines, approvals, and legal authority, questions any competent executive should be prepared to answer clearly and honestly. Taken together, the judicial and congressional challenges reveal a troubling pattern. A senior official appears either unwilling or unable to respect the legal constraints inherent in her office. The judiciary is questioning whether court orders were deliberately ignored. Congress is questioning whether it is being misled. These are not partisan squabbles or policy disagreements. They are foundational issues concerning the rule of law. Disagreements over immigration policy are legitimate. Defying court orders and evading legislative oversight are not. The accumulation of these issues suggests not isolated missteps, but a systemic disregard for accountability mechanisms that are essential to constitutional governance. The broader implications of this unfolding crisis extend far beyond any single official or administration. What is being tested is whether the guardrails of American democracy still function when placed under real stress. The Constitution deliberately divides power among co-equal branches to prevent concentration and abuse. When executive officials ignore judicial orders, the balance collapses into executive supremacy.